Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So, yeah, I thought I'd bring people on. I'm kind of tired of this trial and the fact that it keeps going, but it is what it is. And I've got a lot of requests. People were asking me, hey, can you talk about sort of what happened at the end of it? And I'm hoping this is the end. We know that there's a possible appellate filing, but at the end of the day, we still have yet to hear that Amber has gotten all the money together for that appeal. And if she doesn't get the money together, well, that'll be the end of it. And here's hoping, because everyone involved in this kind of deserves an end to this. Now, let me just see if I can adjust my camera a little bit. As per usual, it is not really where I'd like it to be, but we've got a bunch of things to go over here, and I'm just going to pull up my camera adjust here. All right. Let me just see if I can tilt it a little bit. Wrong direction. And maybe zoom in a little bit more. How about that? There we go. All right, so okay, so what we've got on this one is a whole lot of stuff to go through, and some of it is fairly spicy, which is kind of nice, because if we're going to be going through a bunch of legal paperwork, it's kind of nice if there's some action to it. And man, does this one have some action to it. So let's, I guess, start with kind of at the beginning, I guess, which is there's a couple of memorandums here. One of them is a motion to strike the defendant's out-of-time supplemental memorandum. So this is basically what happened is that the Depp team actually asked for the heard post-trial motions to not even be considered by the judge, to not even be looked at, because what they said is, hey, you should just throw this out in its entirety. Now, of course, that isn't what ended up happening, but it's still worth looking at here. So let's bring this up here. I'm just going to sort of muddle my way through the technology here. All right, so and I see Jennifer Edwards. Thank you very much for the $10 tip for Potter and Zora treats. Thanks, Runkle, for all you do. Yeah, Potter is not super happy because he had to get put in the plastic cone again because he was trying to chew his stitches, and unfortunately, he's still able to do it while he's in the plastic cones. We've been having to watch him. It is what it is. I'd really rather that we could put him just in the what do you call it? Just in the inflatable one, but that's not the case. All right, so plaintiff's motion to strike defendant's out-of-time supplemental memorandum in support of her post-trial motions. There is some snark in this one, which is why it's fun to go through. So plaintiff, which is John C. Depp, by and through his undersigned counsel, hereby moves this honorable court to strike defendant's supplemental memorandum in support of her post-trial motions, stating as follows. So if it gets struck, the effect of that is that it's as if it was never filed, right? It no longer exists in the court record. And at that point, it goes away, right? It's just that it doesn't happen. So they're basically asking the court to entirely throw it out, like make this go away, which the court is going to be reluctant to do for a couple of reasons. We already know that they haven't granted it, but in actual practice, the court tends to be reluctant to strike somebody's pleadings for, because it's a resolution, but it's not a resolution kind of on the merits of things. So argument, first point, defendant Heard's filing is untimely. So pursuant to the court's direction, Ms. Heard's deadline for submitting her post-trial motions fell on July 1, 2022, 1 full month after the jury rendered its verdicts. Now, I'm going to talk here a little bit about law school, because law school was a bit of an adjustment here, because when I went to law school, I went from sort of a world of university where typically the late penalties were like, if it's late by a day, you'll lose a half mark each day kind of thing, right? So there was a little bit of wiggle room. And then I went to law school, where the typical rule was if it's late by so much as 15 minutes, you're not submitting it. So that was a bit of an adjustment, because I was, with attention deficit, I was kind of habitually late submitting things. So, but the reason why is because deadlines in law can be super important. You can actually have it so that on Thursday, you might have a case that is a valid case that is a virtual certainty to win and will bring your client millions of dollars. And on Friday, your client has no case, and you in fact are liable for those millions of dollars because you screwed up and you missed that key deadline. So deadlines can be super, super important. So I see Sky is a neighborhood towards doggo treats or another comforty beds. You and Potter can have one each. Yeah, the backstory on that, folks, I posted about this on Twitter. Potter is still not able to handle long lengths of stairs. And so my wife and I, it takes stairs to get to where we sleep. And the dog doesn't want to be left on his own, but he can't come down the stairs. So to keep him from being upset, I have been sleeping sort of next to him. And we have this nice mattress that we got for that purpose. Unfortunately, the dog has decided that he likes the mattress better. So he took over the mattress, and I was left sleeping on like a camping mat there. So the dog is kind of running the show there. All right. So we see, I see somebody in the chat saying deadlines are important, thus the word dead. Yes, your claim can very much drop dead at that point. So they say it is undisputed that Ms. Heard did not file her supplemental memorandum until the afternoon of July 8th, 2022, 1 week late and only fewer than 3 days before Plaintiff Depp's deadline for submitting his opposition to defendant's post-trial motions due on Monday, July 11th, by no later than 10 a.m. Now, I just want to scroll up here just so you can see this. Filed. They got it in on the 11th. But they are pointing out that they had, that they only got the 3 days. This is another reason why filing late is typically a problem, because the court will set up a filing schedule for side 1 files at this time, side 2 files their opposition, 2 weeks later. And that those deadlines are set up to allow for that 2 weeks, so that the second side gets a fair time to respond. And in this case, because Ms. Heard's counsel, Brett Hoft and company, because they filed late, it actually made Depp's team have to, do their work in a panic, right? They had only 3 days to do it. Props to them for getting it done in time, because this stuff, as much as these documents are not super long, you can see it's a 4-page document. It takes a while to actually prepare them. These require a lot of work. And I see somebody saying, I see 3 days was also over the weekend. That is a good question. It is. They filed it on July 8th. July 8th was a Friday. So 9th, 10th, 11th. So, yeah, they made Depp's team cancel their weekend plans, and that's kind of a jerk move. If you do this a lot in practice, you will develop a reputation, and it is not a good reputation. This is the kind of thing that if you do it to opposing counsel and you do this on purpose, and there are some lawyers out there who love to file stuff at the late afternoon on a Friday every time, you kind of get a reputation for being a bit of a jerk. This is a jerk move in the legal field. So, yeah. So they and only 3 days, and late by no later than 10 a.m. They got it in 8:20 a.m. So they got their time in just right. I love this here. This is where we see Ben Chu's team being a little bit snarky back. They've lost patience. True to form. Yeah, that is that's a bit of prodding. Now, this is the kind of prodding that you can only get away with if you are pretty sure the court is going to be in agreement, because this is the sort of thing that you can get smacked over if you are doing this with, unjustifiably. If you just put this as a dig on opposing counsel and you didn't have a good backing for it, you're going to catch some fire from the judge typically. So the fact that they feel confident enough to drop this tells you just where we're sitting here. So defendant neither notified plaintiff of her forthcoming supplemental memorandum nor sought leave of the court for filing it 1 full week out of time. If you're late, you have to ask the court's permission to do stuff, right? You have to go into the court and beg forgiveness to say, hey, I screwed up. I need to file this thing late. Please allow that. And yeah, they didn't do that. That's bad form, and it is a perfectly valid reason for them to refuse to listen to it. This is a perfectly valid reason for the court to strike it. I'll explain why I think the court did not go with this valid strike or with this motion to strike, even though I think that Judge Ascarati could have. So because Ms. Heard filed late and without leave of the court should grant plaintiff's motion to strike. I think that would have been a perfectly acceptable thing for the court to do, but there's reasons why the judge wouldn't do it. So, and I see, can a judge impose financial penalties on counsel? You bet they can. She doesn't seem to have. She seems to have been very reluctant to do so, and I suspect that's to prevent any arguments on appeal. So that's probably actually to Johnny Depp's benefit that she hasn't been laying the smack down, although I really wish we were seeing it. I still really wish we were seeing it. Second, Ms. Heard had access to the purported new, scare quotes, facts months ago. In her supplemental memorandum, Ms. Heard does not, because she cannot make any proffer as to why she could not have discovered the new facts until now. Now, this is, a thing where normally if you're trying to allege that there's some fact that is now a reason to throw out the entire trial, you'd have to back this up as to why it is not your screw up that this fact was not discovered. So as an example, you might say, I only discovered this witness exists now because the other side, the police say, if it was a criminal trial, because the police never told me this witness existed. I could not have discovered this through diligent research. I only discovered it just now. Therefore, it's not my fault. Because if you could have discovered it, the court is going to say, well, then you chose not to. That is on you. And I see my beloved dog had ACL surgery, carried her up and down 3 flights of stairs for toileting, or using a towel like a sling under the belly so doggy can squat without weight on legs. Yes, we have a little doggy sling for that. And what is it? But we can't carry him up the stairs because he is a big dog. He weighs about as much as I do. So yeah. Is scare quotes a Canadian term or a Runkle term? I thought it was just a general use term. I've seen that used in lots of articles. So, yep. All right. So this is because the clerk's office provided the pre-panel jury list of the parties back on April 6, 2022, more than 2 months ago and 5 days before the jury was impaneled. We're going to see this referenced again. In a rare moment of candor, Ms. Heard admits that she was aware of the purported discrepancy in Juror 15's birth year from the very start of trial, because Juror 15 was clearly born later than 1945. Oh man, this is the kind of snark that you really want to be, that you just, as a lawyer, really wish you could deliver more often in filings. Because this is the kind of accusation, this is the kind of suggestion that, as I mentioned, will get you potentially smacked down by a judge if the judge isn't already in agreement with you. In a rare moment of candor, which means this lying sack of crap right here, you don't get to say stuff like that unless you've done the work to establish it. And I think Ben Chu has. So yeah, this is the kind of things you just love to be able to deliver there. And, Juror 15 was clearly born later than 1945. Yes, that is I mentioned this in a previous stream. This is basically an admission that they knew it and that they held on to it and they didn't make it, any issue of it. That is a tremendous admission. And I pointed that out, on streams beforehand, just to say, like, that is such a damaging thing for them to have admitted. All right. So Ms. Heard therefore concedes she had more than enough time before the trial started and during the 6-week trial, when at least 2 alternates were available, to investigate and discover the alleged new facts. Clearly, Ms. Heard waived any right to allege new facts, quote, scare quotes around facts. I love that. She chose not to investigate for so long, much less to demand the extraordinary remedy of a mistrial. Now, let's break this down a little bit here, because the 2 alternates being available is critical, right? Because let's say that Ms. Heard's team waited not as long as they did, but just until they were going to decide which jurors were the final panel, right? They could have said, whoa, we got a problem with juror 15. And the court might have said, you know what? We agree with you. This is a problem. We're going to toss juror 15 and seat that other juror, the one, one of the ones who got sent home. But Amber Heard's team chose not to do that, notwithstanding the fact that they had to have known about this issue. So, yeah, this is basically them sitting on the issue up until the only remedy that could be granted is a mistrial, or telling them to pound sand. Guess which one the court is going to pick. All right. Are the Amber Heard lawyers being directed by her or the insurance company that don't want to pay the judgment? I think that they're being what we've seen from the insurance filings is that she has independent counsel. So they are not taking instructions from the insurance company. They are taking instructions from Amber Heard. Amber is the one telling them to do that. So that is, that's the answer to that, is just Amber's calling the shots here. But the filings that we're seeing are weak. So, yeah. 3 is a big one. And I mentioned this on streams as well. Ms. Heard cites no unfair prejudice. So even if she had filed her supplemental in a memorandum in a timely manner, which she did not, and even if she had not waived her right to raise this alleged issue by sitting on the information for more than 2 months, which she did, I love the writing here. I love this is dropping the hammer over and over, and you just love to see it, because you so rarely as a lawyer get to do this. This is where you get to just go to town. This is where you get playful. And you don't normally get to get playful in this kind of way where you can bat around the opposing side and just dunk on them. Normally you've got to approach their position with a little more respect. You want just a little touch of, derision. You want just a little touch of, the other side's argument is clearly a bad argument. But you don't normally get to drop this kind of level of, at least not here in Canada. Maybe the US is a little different, but this is fun to watch. And there's another little thing I'm just going to point out here in a moment here that where we'll see some parallelism. And I want to see that. So somebody says they were seeing that Amber's motions were rejected. They were. We're getting to that. But we're going through the filings first. So I have covered Amber's filings, and now I'm covering Depp's filings, and then we'll cover the ultimate response. So if you watch my lives on this, it'll sort of end up being the complete story, is kind of the idea. All right. And that's why I'm not doing sort of a review of the previous filings, because they're already up there. You can check them out. All right. Failed to cite any unfair prejudice. And prejudice in this case is something that would result in the juror, in finding that the juror was biased in some way, that the juror was more likely to find for one side versus the other, that they walked in without without an open mind, or at least the ability to put whatever. I mean, nobody is perfectly open-minded, right? There is no human on the planet who, is, unless they were like just at the maternity ward, like they were just born. And I mean, then they're not going to be a terribly useful juror because their interest in the Depp trial is probably fairly minimal at that stage. But everybody has some degree of biases, some degree of, these things. But the question is, can you put them aside? Can you rule fairly in a, can you rule impartially, even though you are recognizing these, these biases? So, and Jessica Lang, thank you for the $2 and hit that like button. So, and I see, did we talk about the new docs released about Amber Heard's settlement attempt just prior to trial? I have not seen that yet. So, yeah. Leslie, Runkle, I hate guns with a passion and therefore won't sub, but I hope you made contact with all of the police in your area. Well, I think subscriber mode is on, so I guess you must have, at least for this. But, I mean, that's your call. But if you want to learn more about a thing you hate, which is worth doing, it's worth, I am subscribed to channels I agree with, and I'm subscribed to channels I disagree with, because I like to get information that from all sides of things. I want to get, and sometimes you look at sides you disagree with and you go, yep, this is, but so long as people are making good arguments and so long as people are reasonable in how they discuss things, I don't want to narrow my own frame of thinking. I listen to some anti-gun stuff just to see, hey, are they making any good points? Is there anything here I need to think about? So, all right. Even assuming Arguendo, Ms. Heard's latest thesis, now I'm just going to ask you to, to think a little bit here about, we're going to see this phrase, this turn of phrase is going to show up again later. So just remember that. Just remember this little term of phrase. Now you might be wondering, what does this mean? Well, when you say, let's assume this arguendo, it means for the sake of argument. We think this is BS. We think that this is utter crap. But if it wasn't crap, then what would that mean? Let's, and that basically allows us, it's a thing you often want to do in law because people will make multiple arguments. They'll say, you should find for me for reason 1. And if you find for me for reason, if you don't find for me for that, then you should find for me on reason 2. And if you don't find for me on reason 2, then on reason 3. And so basically you might want to say, if you, even if we assume that their first argument isn't, trash, then their here's why their second argument must fail too, and that sort of thing. So that is kind of why you end up having to play with these ideas and basically going, so you'll see in legal writing a lot of, if I'm wrong about this, then I'm still right in the conclusion. And that is just kind of how it goes. So Barbara Schultz, thank you for the super sticker here. And I see Sky's a Neighborhood with a really good comment here. I really feel for Juror 15, basically being accused of all this wild fraud when they were doing something they were summoned to do and take 6 weeks of their life to listen to. Yeah, Juror 15 has really been done dirty here because, let's say Juror 15 now wants to ever do an interview. And keep in mind, there's money in doing an interview at this point. They can potentially get paid for an interview. If Juror 15 comes in for an interview, what do you think they're going to be asked about? Oh, well, isn't it true that you're this giant fraud and you, they really did Juror 15 dirty in a way that they owe an apology for and they will never apologize for. And it makes me salty. So, yeah. I feel like the only way to make informed decisions on anything is to listen to things you both agree with and disagree with. P.S. Runkle, you crack me up. You have a great sense of humor. Well, thank you. And yeah, I think that you got to listen to both sides. And I sort of have a rule about friendships, in the sense of, for me to consider somebody a really close friend, I need to have disagreed with them about something and something that matters. And, if we can walk away after that and come to the point where we can, where we're still friends, that is somebody who likes you because they like you as a person, as opposed to somebody who likes you because you're a mirror, somebody who's the echo at the Grand Canyon. Because there's lots of people out there who you'll talk to and they'll like you so long as you're reflecting back their own opinion at them, but in a different tone of voice. So yeah. All right. Somebody says, can you take us back to Juror 15 and what you wrote about him in your journal during the trial? I might have to do a separate video on that because I'd have to go through all of those journals and look at them very carefully. But that'll be for another time. I've still got those journals sort of tucked away there, so I'll have to have a look at that. And Nikki, we're getting to that. We're going to get to that. So, all right. So even assuming Arguendo, her latest thesis, that a son served instead of his father, there would be no prejudice, as Juror 15 was qualified to serve as a juror in Fairfax County and was vetted by the court and the party's counsel, just as all the other jurors were. So you can't show any prejudice. You can't show that this was a biased individual. All they were trying to do is throw smoke and illusions and try to turn nothing into something. They're trying to basically turn this tiny little who gives a crap thing into this, major conspiracy and so forth. It's sad Amber Heard used post-trial motions as PR tactics. It's a great thing the trial was broadcasted. We all got to see the real truth. Have a great day. Yes, absolutely. I have said before that I think that it is fantastic that this was broadcast, because if it wasn't broadcast, Johnny Depp would still be getting slammed in the media and in the public view, because nobody would have any different, nobody would have anything to contradict it. And yeah. But just remember this paragraph in terms of how it was phrased and how it was structured, and see if it doesn't seem familiar a little later on. All right. So conclusion: based on the foregoing, the plaintiff should grant the court should grant plaintiff's motion and strike defendant's supplemental memorandum. So, and they block out the signatures, and the reason why they do that is because they don't want. This is actually kind of an interesting thing, because it has happened in my jurisdiction as to people doing this. What sometimes happens is, the criminal courts or the courts are full of people who, some people in court are good people and some people in court are bad people. And sometimes people want something from the court that the court's not going to give them. So sometimes people lift things to, from, court orders and then create fake court orders. So that's why they block that out, is to prevent that from happening. So that is why they've done that. All right. So I see. Do you think that pro-Heard media groups will come after Juror 15 when the juror information becomes available in a year? I'd hate for his life to become a living hell over this nonsense BS. I really hope that they don't. I hope that they will have moved on with their lives in a year, because come on. I hope in a year I'm looking at other cases. I'm looking at other stuff, and, yeah, it's, do I think Depp will win in his attempt to have the $2 million damages reduced because it's excessive? I suspect that this is not going to get touched at all. So, yeah. All right. So let's have a look at there's a larger memorandum here, which we're not going to look at in full detail. We're going to go through in brief, because it is 36 pages long, and ain't nobody got time for that. That is just not something we're going to do here. But we will look at it in brief here, just to sort of cover the points. So once again, we see that this one was filed at 8:21, July 11th. So if we look at the timing of that, I'm just scrolling up here, 8:20 on one, 8:21 on the other on July 11th. So they filed both at the same time, and it was just one got stamped at one point, and the machine ticked over to the next minute when they stamped the other. So he says, NBC did a disgusting documentary on the trial. Guess whose side they're on? I don't even have to guess. I can just imagine this. And truth to the rumors, you've been cast as a young Gandalf in the Rings of Power. I wish. I wish. That's not likely to happen, but it's a really cool notion. I see. Thank you for the $10. Hugs to Potter from Java. Wow. That is so. And I see good thing Rittenhouse was broadcast, but the president and media still didn't report it correctly. Yes. And you know what? I suspect that there's lots more trials out there that people are relying on, including some big Canadian ones that would have been very different if we had them broadcast. And on vacation and watching you from Banff. Banff is beautiful. So check it out if you're looking at vacation destinations. It's a pretty awesome place. All right. So plaintiff's memorandum. So the other one was a motion to strike, and it's going to be short and punchy and to the point. This is longer legal writing in order to address these motions. And you can see it's real long. So I'm just going to summarize these points real quick just to try to give you guys an idea of what all is going on. But we're not going to go through things in all the detail because otherwise people are going to be napping, and that is not where we want to be. So what date do they have to file the appeal? I think that it's like 11 more days. I got to check. I'd have to check the actual date, but they have just a little bit more time to get together all the money to file the appeal. So he says, as a former paralegal, such a satisfying feeling having that stamp on the motion you filed with the clerk. Yes. This is the other thing, just as a bit of like legal practice. The clerk doesn't always file stuff. You can go in and they can be like, so I'm not going to file this because you got the formatting wrong, or the cover page is the wrong, the cover is the wrong color. And so when you're filing things on the Monday morning of, it makes you a little nervous when when you're sitting there waiting as they look over it to file it, because if they didn't file it, they would have 2 hours to get this right. I can guarantee you that Ben Chu's team would not have been filing this at 8 a.m. on the deadline, if not for the fact that Amber's team screwed them with a late filing. So they would have been doing this on Friday or Thursday, just so that if they go in and it doesn't get filed, that they've got some time to fix it and try again. Because when that stamp gets landed and that the document is actually in and it's actually going to be accepted and the court's going to listen to it, then yeah. So Deborah Wade, thank you for the super sticker there, and let's have a look. Clarence Obert, after Judge A signature on the order, look at the small print below. Another law nerd said the verbiage is a slap to EB, as they normally have the lawyers endorse the order. Thoughts? We'll get to that. And yep, so let's keep going here. Whoops, and I see somebody saying, I think the real Laura B will be getting hold of them. I hope so, because that is going to be interesting for sure. All right. So, following a 6-week trial, a jury of Ms. Heard's peers rendered a verdict against her in virtually all respects. I mean, they did award her $2 million, but her $2 million is a tiny little stack of money when compared with the giant stack of money that they awarded Johnny Depp. So, hello, magical elf. Do you think the lying narcissistic community will recover from this justice? The lying narcissistic community is going to be fine. There's no shortage of them. Though understandably displeased with the outcome of this trial. Yeah, that's I love that. Ms. Heard has identified no legitimate basis to set aside in any respect the jury's decision. Virginia law is clear that a verdict is not to be set aside unless it is plainly wrong or without evidence to support it. Here, the verdict was well supported by the overwhelming evidence consistent with the law and should not be set aside. Mr. Depp respectfully submits that the court should deny Ms. Heard's post-trial motions, which verge into the frivolous. Let's talk about this word. Frivolous is often paired with another word, which is vexatious. And you don't normally call your opposing side's arguments frivolous, and you certainly wouldn't normally call them vexatious, because those are terms that kind of have some meaning and kind of suggest some badness. We'll go with that. So I think they're there when they're making these arguments, but it's a big word to use. So yeah, and I see Kurt says it's like F off. Yes, that is a good way of putting it, because I don't think I've ever called a Crown prosecutor's arguments frivolous. I've asked for the court to throw out their case without, without hearing from me, which is what we call a non-suit, which is basically just the Crown has not even gotten, they've not even gotten close enough to a case that I have to respond to it. Which is basically saying this case is utter trash, like there's nothing there, or they have forgotten and they've missed some critical element that was necessary for them to prove their case. And I still don't call it frivolous. So frivolous is a big one. And I see somebody was saying no gift option. I don't know how to set that up. So I'll try to look into that, but I'm not going to be able to do that while I'm running the stream. So that'll be something else there. So, and I see Skies in the Neighborhood was saying, I find it so interesting to hear about the being a lawyer bits like stamping or language in motions. And of course, lawyer jail, which blew my mind for some reason. Somebody's saying the Crown. I am a Canadian lawyer. So the government is like, the prosecutors are called Crown prosecutors. They are in theory representatives of Her Majesty, the Queen of England. In practice, they're just the person arguing for you to get sent to jail. So, you also have Crown lawyers on civil files, because if you are suing the government, it'll be a Crown lawyer who's there to say, government doesn't owe you any money because government reasons. But yeah. So Crystal, thank you for all of your informative coverage and your sense of humor when doing so. I hope Potter's feeling better. Potter's doing good, although he's, it's a healing process. He is where we expect him to be. So, and I see you haven't had time to look at your gun stuff, but I plan to. Love having things explained, if only to make my arguments stronger in discussions. Yes. I like guns, but I talk to people who don't like guns, and man, sometimes I really hope that they have better arguments, because it doesn't end up being super important when it's kind of a waste of time when you're arguing with somebody who doesn't sort of know the basics, which happens sometimes. And I see people asking about, do you get to wear wigs? Not in Canada. We don't do wigs. We do robes, but no wigs. So, and the robes are expensive. Yeah, they are not cheap. All right, so the damages awarded by the jury were supported by the evidence. So they just basically say they should only correct a verdict when it's so excessive as to shock the conscience of the court, or to compel the conclusion that it was the result of passion or prejudice or some misunderstanding of the facts and law. And they can't arbitrarily substitute their judgment for that of the jury. But, they go on to basically say, while Ms. Heard slings an exceptional amount of mud at the wall in the hope that something might stick, ouch! The jury's verdict on damages was perfectly reasonable and supported by the evidence and testimony in this case. For instance, Mr. Depp's manager, Jack Wigham, testified to the following. So, in 2017, after the public allegations, but before the op-ed was published, and I'm getting pop-ups here that I'm just going to kill, Mr. Depp filmed multiple pictures, including 3 studio films for which he was compensated between $8 million and $13.5 million. It was a typical year. And he had his specific plan in 2018, so that's why he wasn't filming any movies, because he was doing other stuff. And when he was asked if he lost roles, yes, after the op-ed, it was impossible to get him a studio film, which is what we would have been focused on in that time period. So, yeah, right there, that is enough for the jury to get to that decision. So I mentioned before that this was not likely to be successful, and this is, the Depp team is going with basically the same reasons I was saying, but I'm not claiming credit here. I'm just saying it was the correct answer. So, yeah. When is the appeal deadline? 30 days from the 24th? Yes, I believe so. So that would make it the 24th now. The wigs are horsehair. I believe that is what they do in the UK, not here. So, And yeah, he's not saying that it's on the verge of being frivolous. It's the way it's actually worded. It implies that it is to some degree frivolous. Yeah. So, all right. So let's skip on here because they talk a little bit more about this. But basically, they're going to say there is plenty of evidence a jury could find lots of money. Cool. Scrolling on to their next point, but they keep going on this. The verdicts on the complaint and counterclaim are consistent. So while jury verdicts that are irreconcilably inconsistent cannot stand, the court will harmonize jury verdicts alleged to be inconsistent if there is any reasonable way to do so. Now, I just want to provide a little bit of sort of an understanding here. It is super common that the courts will look at verdicts that just about anybody else might say are inconsistent, and the courts will bend over backwards and touch their toes with the top of their head in order to avoid finding inconsistent verdicts. It is really hard to get to inconsistent verdicts. So yeah, that is a thing. I see Rakeda sent me. Awesome. I hope I wasn't interrupting or overlapping with one of his streams. I try to avoid that, but yeah. I see she may be slinging things other than mud. Well, this is a courtroom, not a bedroom, so probably not. All right. So here there's no inconsistency between the jury's verdict on the complaint and the counterclaim. And so we'll just, skip a little on here. The jury's verdict on these three statements in the complaint reflects the jury's determination that Mr. Depp did not, in fact, abuse Ms. Heard, and that Ms. Heard was lying about being a victim of abuse at the hands of Mr. Depp. So, carrying on here, they say, as to the three elements of Ms. Heard's counterclaim, the jury determined Ms. Heard did not meet the elements of defamation for the two statements by Mr. Waldman stating Ms. Heard's abuse allegations were a hoax. So Amber Heard and her friends in the media used fake sexual violence allegations as both a sword and a shield, depending on their needs. They have selected some of her SV hoax facts as a sword, inflicting them on the public and Mr. Depp. We've reached the beginning of the end of Ms. Heard's abuse hoax against Johnny Depp. So again, this verdict reflects the jury's determination that Depp did not, in fact, abuse Ms. Heard, so it was not defamation. But the third statement is the sole statement for which the jury found Mr. Depp defamed Ms. Heard. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt did not do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. So they are pointing out that there is, and somebody says, I don't think Runkle has a membership. All his stuff is open. I have a membership, but all my stuff is open. The membership is purely just because some people wanted the membership option. So basically all the membership gets you is a little icon, and I might do some polls, but membership basically is just if you want to be a member to, for bragging rights or to support the channel. But I don't do member locked videos. I don't do I'm not going to put content locked behind memberships because I'm here because I like teaching people. I'm here because I love the law. I'm here because I love sharing the law with people. That's really what I want to do. And that's what I'm about, is I want to share I just want to share the law with people. So I don't want to lock that down. And I have been clear before, I've got a Patreon, I've got all of that, but I've been clear that if you are somebody who's in financial trouble right now, because right now we're seeing, not unprecedented, but we're seeing really nasty inflation, and wages aren't going up, but prices are. I'm seeing my purchasing power decline quite a bit, and I'm sure I'm not the only one. So, if you're somebody who's sitting there going, hey, how am I going to keep the lights on? How am I going to keep the rent paid? How is this going to happen? Well, don't stop your subscription to me if that is, where you are, because I don't want anybody making, like, if you are in that place, absolutely pay, like, so, this is purely luxury, purely whatever, but I don't want anybody out there. If you are, if you're watching this from a cardboard box under a bridge, I want you to have access to it. If you are watching this, because you are sleeping on the sidewalk, not because you're there watching a trial, but because you got nowhere else to go and you're watching this in a TV store window or something like that, notwithstanding that TV's not playing me, but you get the idea. I want you to be able to watch this. I don't want to, I don't want to cut anyone off because of that. So yeah, it's, I'm not, and I'm not going to turn on, I don't ever plan to turn on member only chat. I want you guys to be able to chat with each other. I just, that's the thing. And I mean, my ultimate goal is to be able to run this channel to pay for me to be able to do legal work pro bono for, so that I can help people out for nothing. That is my ultimate goal if I succeed in sort of becoming a YouTube whatever. But yeah, that's sort of my goals here is so yeah, if you're wondering why the subscriber option is not full of like fantastic exclusive content, that's not how I want to be. So I don't really have a good solution for that, for sort of what to offer as subscriber incentives, because anything that I think of for incentives is stuff I just want to give to everybody. So yeah. Mr. Steve, Virginia, and a darn good teacher you are. Well, thank you. And sorry, I'm behind on some super chats here. Lucky Lass, I heart guns. Well, me too. I enjoy. I mean, with my attention deficit, they really help. They really help my focus and my thinking. So yeah. Anyway, we are back to that. I see. It would be nice to be able to send a private gift, though. I did add a PO box address to my about page, so you can find that there. Gino Giannetti, most down to earth, honest man. Follow you for that. Well, thank you. And I see I hate guns. Well, that's fine too. You don't have to like them, but come on out to the range at some point and check it out and so forth. So yeah. All right. So let's keep going here. So they basically note that they could, there are multiple highly specific and detailed factual elements of this statement that the jury could well determine were false, while still concluding that the abuse allegations by Ms. Heard about Mr. Depp were false and defamatory. So absolutely they could do that. Somebody asked if I have an Amazon wish list, and I don't. Maybe I'll have to set that up at some point, but yeah. Somebody says guys used to take their guns to school to put them in their lockers so they could duck hunt after school. My dad used to do that, and he actually mentioned at one point that he got that he was late for school when he was a kid because he saw a deer on the way to school and shot the deer, processed the deer, took it home, and then went to school. So, but that was a long time ago. So the world has changed a little bit. You're an honorable man. Thank you for giving to us so you can help others. Well, thank you. And thank you for the $15 there. And you see, the First Amendment does not bar recovery for defamation by implication, even when the statements at issue involve public figures or matters of public concern. And here we're going to see more of the fun language, the fun words. Indeed, Ms. Heard egregiously and flagrantly misrepresents Virginia law in arguing that the Supreme Court has signaled defamation by implication may not be applicable when it involves a public figure or matter of public concern. They have made no such suggestion, and the out-of-context language relied on Ms. Heard is misleading. Ouch. Egregiously and flagrantly misrepresents the law. That's some fire. That is the kind of thing you don't want to have people. That's the kind of thing I'd be pretty pissed if another lawyer wrote about me. And so I write my legal submissions in a way that other lawyers can't write that stuff about me. Or if they do, that I'm not the one who has to stand up to complain about that because the judge will. I try to make sure that I am handling things above board, and you're going to see an absence of judicial flame coming back at this. And I think part of why um, you don't see as much flame from the judge is that she is basically letting Ben Chu throw his own punches back. So, yeah. All right. So, defamatory innuendo is no more protected by the First Amendment than is defamatory speech expressed by any other means. Cool. All right, moving on. As I said, I don't want to get stuck in this one forever because it is super long. The jury's finding of defamation regarding the op-ed headline was consistent with and supported by the law and facts. This one is basically just, hey, the jury came to a decision that was not crazy. The jury, yeah, the court's not going to throw out a jury verdict. So, yeah. They also note the jury was free to disregard Ms. Heard's testimony that she did not see the title of the op-ed when she tweeted it. Indeed, the title was prominently featured in the tweet. And there's a line here about, credibility is the key metric here. The jury is free when Ms. Heard to say something. The jury is absolutely free to say, we just don't believe you. We don't think you're being honest. We don't think you're being accurate. We think you're full of crap. That is something the jury can absolutely do. So, relying on my client testified to something as a reason why the jury's verdict is improper. I mean, the jury thinks your client is a lying sack of grumpies. So, yeah. For the Pro Bono Legal Fund, thank you, Pam Marshall, for the $20. You're an awesome person, Runkle. Happy to support your efforts in helping people. Legal problems can be so stressful. Absolutely, they can. And yeah. And Easy B, thank you for the £9 there. Somebody says, sounds like your subscriber incentives and content are going to be things that are unknown to law. Yes, unknown to law is. I've mentioned this as a phrase there. Unknown to law is, I've used this before as a bit of snark. When you say, my friend's argument is unknown to the law, it basically means they're trying to make up law. They're trying to make stuff up that doesn't exist. It's a very polite way of phrasing it. And like the court sort of reads what you're saying, but you got to be careful about how you phrase things. And I still don't say unknown to law unless I'm real certain about that one. So yeah, lawyers, legal shade is kind of this art, because let's say you're at the bar and you've got a pint there and it's not your first pint. It is maybe your third or fourth pint. And somebody comes up and they're being a jackass to you. You're probably going to be pretty direct in terms of how you phrase this. You're going to say whatever, like you may swear at them, you may whatever, but I can, in court, I can't stand up and say, my learned friend is being an asshole. You just can't do that, right? And you can't say, my learned friend is full of shit. Court will not put up with that. And in fact, the Law Society may drag you in, they may drag you in and sanction you for that. So as much as you want to say, I think this guy is an asshole and he's full of shit and, fuck him and the horse he rode in on, pardon my language here, the court will trash you for that. So you gotta moderate your emotions. You can't get that pissed off in court. You gotta keep a level head, because your client's going to be upset at all. Your client is unhappy with the process. You need to be the person who can make level-headed decisions. And if you can't do that, you may need to get off the file, because you may lead your client to very bad places if you can't make level-headed decisions. But there are times when you need to communicate to the court, hey, this is a real dumb argument. And so you got to figure out you're going to do that politely and in a way that is not going to get you in some trouble. So that's sort of where this is. Keanu Siamese, hate guns but respect Runkle. Well, thank you very much. Thank you for being here. I like Hoag's line of reasonable minds can differ because, yeah. I got to make that the fuck around we find out merch. I will probably spend some time today working on that. And that's something I got to work on there. Hey, Runkle, with Amber Heard going for appeal, that stuff that Judge Penny disallowed in the trial will be available, such as Drew confirmed Amber Heard spoke with publicists and friends before call to police 2 hours later. Yep. And I mean, Amber Heard wants another trial. Do you think does she think it's going to get any better than it's been so far? Because I don't. In fact, I think that there are some serious, I think that there are some new dishonesties that have come to light that will, in fact, make her a follow-up trial much worse. So, yeah, yeah. And don't forget Kate Moss without a cross merch. I have got to make that too because I called that one. Not the way I thought I was going to, but I called it. It was that was a fun moment there. So, all right. So, yeah, they're basically just noting that the jury had every right here. The jury's finding of actual malice is well supported in the record. Of course, actual malice may be proven by circumstantial evidence, since rarely, if ever, will a defendant openly admit to knowledge of falsity. When is someone ever going to actually get up on the stand and say, yes, I knew I was lying about somebody when I published this? And of course not, right? You've got to actually infer that from the facts around it. You're not going to have that direct evidence. All right. So there was copious evidence that they could find. Indeed, the jury concluded that Ms. Heard lied about being abused, the falsity of which is necessarily within her own personal knowledge. It is pretty much impossible to find that Amber Heard lied about being abused without finding actual malice. Like, how do you separate those two things? So the fact that they even made that argument was that was such a reach. Debbie W. for the criminally underused Runkle swear jar. Yes, sometimes it happens. So, yeah. I try not to swear too much on stream, but sometimes I kind of feel like this one needed like a gin and tonic, and I should have brought that, but I did not. All right, maybe I'll pour myself one in a moment here. By way of example, Ms. Heard obviously knows firsthand whether Mr. Depp struck her on the face with a cell phone on May 21, 2016, a few days before she walked into court with a mark on her face to obtain a domestic violence restraining order and publicly proclaim herself for the first time to have been abused by Mr. Depp, which claim she subsequently renewed in her op-ed. Such facts are inescapably within her personal knowledge. Yes, this is so obvious that I pity the person who had to write this out, because some of the hardest things to write as a lawyer are the bloody obvious points. Case law that has been run, that has been unchanged since like 1870. When you have to actually cite a case for, this is obviously how the law works, and it's always worked this way, and come on. That is really a pain in the butt to research. When you have to cite, when you have to write an argument for the blue thing is blue and not red, it's so tough to write that. These are really difficult. These are really difficult things to write. So I really feel for whoever had to write this out, and just, sometimes you're sitting there going, do I really have to respond to this crap? And you have to, right? This, as much as Amber Heard's filings were so bad, there was so little to them. It's actually, this is not a case where you might just file back a response that says, like, we decline to respond to this. And I've done that, like, I feel no response is necessary about twice in my career. And each time I have won on that issue because you only do that where it's so obviously bad. But you can't do that when there's $10 million at stake. Like, you just can't. So they had to respond to this. Kim Medina, thank you for the $7. Blake Caveni, I was following Emily D. Baker before the trial, and I'm glad she helped me discover you. Keep up the good work. I love Emily. I love her work. It's fantastic. So, yeah. Somebody says, yes, a different type of honesty is the blonde traveler's agent that sat behind Amber Heard's team during the trial, said in her filing this week that she's the one that bounced Gina Duders, not Amber Heard's girlfriend. That I'm going to have to check out there. The other one that's really interesting is that they were saying repeatedly that she had paid, millions of dollars in legal fees when it turns out it was the insurance company. That's a whoops. How much do you think Amber Heard tried to settle with Johnny Depp? Now it's unsealed. Can't wait till we see it. Great work. I want to see that so bad. I'm going to have to, that'll have to be another stream because, yeah. Sending hearts from West Virginia. I'm pro guns and pro common sense. You shouldn't have one without the other. Absolutely. All right. We got random weirdos in the chat. Christy from Meta Studio. Big hugs from North Carolina, USA. You're such a good soul and your channel's awesome. Love a good competitive shoot as an observer, but I have to stick to archery because my aim sucks. Yeah, I also really like competitive shooting. It's a lot of, it's a lot of fun. And it's one of the few things that actually gets me moving and gets me some exercise. Because I don't know if you, I got bony little noodle arms, right? And it's good if I can find something that I can do for exercise. There is nothing that gets me throwing a kettlebell other than the brutality matches. So props to In-Range TV for setting those up, because I did not think that there was any way in life that I would ever be throwing a kettlebell. And then I was throwing a kettlebell. Somebody says, will you be airing the NBC documentary? It's so awful. I might look at it and might look at pieces of it, but I'm not going to sort of do a large scale thing because, yeah. Somebody says, was I also swatted? I have not been swatted. I have had some contact with my police to discuss the possibility that somebody might do it, because I have seen too many recent swattings over this. And yeah. Found Hogue first, but glad I found you during the trial. Your pro bono efforts are inspiring. Thank you for all that you do. The world needs more well-intentioned people. Cheers from Washington State. Thank you. For your fur baby, do you have a PayPal, Ian? I do have a PayPal. I almost never use it. So, yeah, well, I can post that up if people want that there. All right. So, yeah. I'm just trying to find, there's a couple sort of interesting quotes in all of this, but they just note, there's compelling and substantial evidence that her story of abuse was deliberately fabricated. So, yeah, and I think that is an entirely reasonable conclusion that the jury could have reached. In fact, that Amber Heard made a real convincing argument for it, notwithstanding the fact that she was trying to argue the other way. But she really was trying to convince us all of that. Mr. Depp presented sufficient evidence to support a finding of defamation by innuendo. And again, this is the jury's allowed to make this call, right? So they just have to point to some evidence. I'm, again, not going to go through all of this because, yeah, it's just, this is kind of ridiculous here. Now they get into the really interesting one here because the court should not conduct an investigation of Juror 15 because defendant has waived such arguments and has failed to provide any evidence of unfair prejudice or any due process violation. I say that the Juror 15 argument is the most interesting, not because I think it's the best argument. In fact, finding the best argument is kind of like finding the tastiest piece of corn in a grumpy. It is like, her arguments are all real bad. Real bad. This is the most interesting one because it's just kind of exceptional. It takes some real courage to make this argument in, yeah. So So did the guitar strap you crafted make its way to the recipient? It did. I will let the recipient know if they want to, the recipient is the one who can show it off if they want to. But it did make its way to the recipient. So, yep. Are the rumors true that you took part in the newest Lord of the Rings series? They are not. Sadly, I mean, if they want me to do a bit part, I would totally do one. But so the rest of the questions about having to, about elf makeup, well, yeah. All right. So, like, this is the argument that is just like, I would not have made this argument. I think that this argument was a real bold move. And yeah. So Ms. Heard's desperate after the fact demand for an investigation of Juror 15 based on a purported error in his birth date is misplaced. Yeah. So as a threshold matter, Ms. Heard waived her right to challenge the accuracy of the information in the jury panel by failing to raise this objection contemporaneously. See Supreme Court rule and Virginia court rule that says it shall be sufficient that a party at the time the ruling or order of the court is made or sought makes known to the court the action which he desires to the court to take his objections to the actions of the court and its grounds therefor. So basically, just you have an obligation. When you object to something, you have an obligation to stand up and say so, right? You've got an obligation to stand up, like to actually let the court rule on it. Because if you don't let the court rule on it at the time, then, then the court's not able to address that. And I'm just going to try something. I hope I don't get disconnected. I am seeing that I'm having some low connectivity, so I'm just going to try fiddling this. Guys, let me know if there was an interruption here, but I was getting some signal warnings from StreamYard, so I've turned off my my VPN. Hopefully everyone can still hear me. Give me a thumbs up in chat if that's the case, and let's keep going. So they note the main purpose of the contemporaneous objection rule is to alert the trial judge to possible errors so that the judge may consider the issue intelligently and take any corrective actions necessary to avoid unnecessary appeals, reversals, and mistrials. Yes, you've got to appeal, raise the issue at the time, because otherwise you might end up with the court saying, let's say you say, hey, let's consider the possibility. If they had said at the time, hey, Judge A, that juror is the wrong juror. Judge A probably would have said, as an abundance of, out of an abundance of caution, just because this is such an important thing, Juror 15, go home. She probably would have done that. In a hot second, I think she would have done that if that had been raised during the actual trial, because she doesn't want to risk this thing going to appeal. And she had 2 alternates. She was good to go. So why wouldn't she have just sent him home? It is entirely likely. Now she's saying, oh, well, because I didn't object to that, now the only thing that can happen is a mistrial? No, go away. That is just such a, yeah. All right. So further, there's a procedure for objecting to the irregularities, and they note this, that it must be something that will probably cause injustice. And yeah, they keep going. They note, contrary to Ms. Heard's contention otherwise, the parties do have a statutory obligation to verify the accuracy of information listed in the jury panel before trial, and any errors are not grounds for a mistrial. And they cite the law, which was noted, because Ms. Heard was trying to say that it was the court's responsibility, and the law says that the parties actually have to do that work. And they note here, they say no evidence of prejudice or injunctive, therefore, and they cite a case where 2 convicted felons sat on a jury, which was not discovered until after trial because defendant made no showing of injustice. Yeah, it's finding defendant's objection to the qualification of a juror was untimely. This is another case where defendant had knowledge of the fact that a brother of a sworn juror would be a material witness in the case, but did not make an objection until after brother's testimony was not in accord with what he hoped and thought it would be. Even if this is an example of the kind of thing where the courts get real upset. This case that's being cited, because this person basically knew that the brother, like that the juror was related to the witness, and hoped that would be helpful, but then didn't actually raise that until after they basically went, oh, this witness is bad for us. We thought this witness was going to be good for us. So we're not actually going to, now we're upset about this. It's like, that's not how this works. That's not, something that we're going to, do here. So, all right. So, moreover, Ms. Heard's argument is based on pure speculation. She cites to publicly available information that he was born in 1970, but fails to attach such information to her motion or otherwise identify it for the court. This is kind of a thing in law where if you want to make an argument based on facts you're alleging, you need to actually provide the evidence. Like, you can't just say, we got evidence, but you can't see it, court, because of reasons. And you can't, I don't think they even say because of reasons. They just say, you can't see it. And I'm going, are you kidding me? Like, you have to actually, if it's publicly available information, you have to actually show your work. Like, is this voter rolls? Is this, a homeless guy on the street who was ranting? Like, what is the level of information? It is absolutely, yeah. And it sounds, I'm seeing people saying that Rob is going to lose his mind when he sees Elaine in the NBC documentary. It sounds like I got to watch this documentary. Why are you guys making me watch that documentary? Why? All right. Carrying on here. While Ms. Heard has a right to an impartial jury, she fails to identify any way in which this, was not an impartial jury. She cites to no case law to support her argument. Yeah. She makes no showing of prejudice, and her speculative arguments fail. This was just absolutely ridiculous that she was just, I was saying basically, you can't just have an idea of something that might happen. You have to actually, give evidence. You have to actually provide, you have to back stuff up. You say, and so you note here, mere suspicion or possible inferences cannot be allowed to overrule the orderly administration of justice, for otherwise there would be continued delays and many proper verdicts set aside. The importance of avoiding another trial, if the first trial is fair, is of paramount importance. And even if we assume that a son served instead of his father, there would be no prejudice, as Juror 15 was qualified to serve as a juror in Fairfax County. So this paragraph basically looks very similar as their other motion. Such speculative arguments, unfounded in law and without factual basis, are improper at the post-trial motion stage. At this point, after a 6-week trial was held, the court should exercise its discretion and reject Ms. Heard's belated, speculative, and clearly pretextual arguments regarding Juror 15. Ouch. Pretextual arguments basically means that they are a false argument. They're flying a false flag. They're saying, this is our issue, but really what they want is, in this case, really what they want is they want the verdict thrown out. They don't like the verdict. They're unhappy with the verdict. They would absolutely not agree that this was an issue at all if the verdict had gone the other way. So, yeah. Kathy Richardson, thank you for the $5. We like sweary Runkle here in Kansas City. I've heard people saying tired Runkle is the best Runkle. So, yeah, it's, was it? EDB watched that documentary and has pointed out that Umbridge was interviewed from a room with pink walls, and that's it, really. I'm going to have to watch that one. This is so, I really like that that Ben Chu kind of took the chains off for this one and was just gonna give it and go for it, because this is such a he's saying all the things I wish I could say on this one in a legal filing. And I can be more direct, but I wish I could say this stuff to the court, just be like, come on. But I got no standing. I'm not a person who can go in and just be like, come on, are you really going to listen to this? So, conclusion, for all the reasons set forth above, Mr. Depp respectfully requests that this court deny Ms. Heard's frivolous motion in its entirety and reject her outlandish request to set aside the jury verdict, dismiss the complaint, or in the alternative, order a new trial and investigate Juror 15. So, yeah, they came at that hard, yes? Real hard. So then we get two verdicts, and I'm going to look at the less interesting one first, or at least the less interesting but more potentially interesting later down the road one. And I'm going to look at this briefly just to, but yeah, this one is just kind of interesting because of all the stuff we're going to get access to in future. Now, remember, Elaine did not want this to happen. Elaine wanted all these documents to stay sealed forever, but the protective order in this matter was put in place to protect sensitive information and to ensure an untainted jury. In this matter, both litigants sued one another, thereby opening themselves up to the public forum of a jury trial. Court records are public information. This is an important principle. Once upon a time, most court stuff happened kind of, in basically closed rooms. Like the parties would walk in and they'd walk out with a verdict, but you couldn't actually go in and see what was happening. This is like pre-US Civil War. And this is one of the reasons why the US was sufficiently pissed off to start a civil war, because these kinds of trials were inherently suspect and inherently suspicious. And people were very, this was upsetting to people, because how do you know that justice is being done if it's being done in secret? So because of, because there was such a reaction to this, the tradition has really changed quite a bit, such that the expectation is that trials will be held publicly. It is the expectation, and we deviate from that only for rare and specific reasons. As an example, in Canada, let us say that you have a child witness, and that child is, the allegation is that child was subject to some seriously bad things that we will not specify, but I'm sure you can sort of read between the lines of what I'm sort of implying here. And, things that you don't want sort of following this child victim for the rest of their lives. That courtroom will still be an open courtroom. You can walk into that courtroom and watch it if you want. But they will, here in Canada, issue what they call a publication ban that prevents the media from reporting on anything that would reveal the identity of that child, which means that the media can still report on the allegations, the facts of the case, what happened in the case, why the judge made their determination one way or another, why evidence was allowed in or not allowed in. These kinds of things the media can still report on. So notwithstanding that is an extremely sensitive case, they will still report on it. I've been involved in some litigation with the government, and I have, fought the government over some gun issues. I am, in fact, the leading case on a particular aspect that enforced some procedural rights for Canadian gun owners. As part of that, my address got filed, and I got an order, because I'm a criminal defense lawyer, sealing the release of that address. You can get everything else in that document, but it won't tell you where I live. And that I think is fair. But you can get every other document. You can get the transcripts. You can get every other piece of information. We just reveal information. That's how we do it. All the happy squirrels, thank you for the $5, and for the pupper treats, yay, sweary runkle. Would love to see a LawTube ranty screening of the mockumentary. Oh man. They say they are unsealing, but the transcripts are very expensive to get. From all that others are saying, they are very expensive to get. Transcripts are expensive, so that is unfortunate. All right, so they say, it appearing to the court that certain filings in this matter should be unsealed, it is therefore ordered that the following documents be unsealed. And I'm not going to read through all of them, because it's a long list. There's a 6-page, it's 6 pages in this order. But Elaine Bredehoff very much did not want this unsealing. She wanted all this stuff kept quiet. And I'm guessing there's going to be some review there. M Noodles, why aren't all her attorneys telling her that she's only making things worse, that nobody's buying her crap? I suspect they are, but she's not listening. My God, will she ever go away? P.S. I very much enjoy your channel. Thank you. I hope she does. And Ricada, I wouldn't want to belong to a LawTube that would have me as a member. There is no such thing as like a membership to LawTube. It's just a descriptor. So I'm just sort of showing you this list here. It is long. You can find this online. But I will just point out very briefly here that they note here, there are some documents that are going to remain sealed. And I'm just going to look at some examples of why. And it's just, for containing a home address, that'll remain sealed. For containing personal contact information, sensitive personal medical information. So I really like that she's identifying all of the documents that are remaining under seal and the reasons for why it's remaining under seal, so that we can see that the court is doing this in a fashion that is fair and open, and that there are good reasons for the stuff that is not getting shared with the public. So, and some of the documents that are really interesting here is there are some aspects with respect to, some procedural stuff, but I'm noting a lot of people want to see stuff on the settlements, and that I'm curious about. So I want to see some details on all of that. I want to see, all of this stuff is going to be really interesting in terms of what all we see on this, because that'll be coming out and we'll have to sort of pick through it as we can. But yeah, so the next thing I just want to look at, and this will be the last thing here, is the final order, because the final order is it's full of snark. It is full of judicial snark. And I am a fan of judicial snark. Everywhere I see judicial snark, I love it, because it is this really interesting variety of low-key sense of humor. It is a really interesting variety of yeah. So let's have a look here as we go. And Secret, thank you for being out here, and good luck with the hospital visits. We really we hope you're well. If you can check out, I retweeted it. Secret McSquirrel also tweeted it. They've got a coffee page for, they're going through some medical issues and so forth. So if you feel inclined to chip them, they help out all over, lots of people's channels. Great mod, great, person who volunteers their time. So if you can help them out, that is, that's fantastic if that's something you'd like to do. All right, so let's have a look here at this order. All right, we'll just make that panel go away again. All right, so Depp and Heard order. This cause came before the court upon defendant Amber Laura Heard's post-trial motions. After review of the defendant's post-trial motions, plaintiff's opposition, and the relevant statutes and case law, it is therefore ordered as follows. Defendant Amber Laura Heard's post-trial motions 1 through 6 are denied for the reasons stated on the record. Now, this, you might not realize, is typically some snark, because one of the worst things on a verdict is when they just so I had a case where I was alleging a whole bunch of reasons why the lower court was wrong, and the higher court just basically said, we find that the lower court decision was in error, and that's it. That's all they said. And that basically means that you think that those arguments are really weak and that they don't need a whole lot of further analysis. I don't think that they had to. I don't know if they did any further verbal argument or anything else, or if they just got this written order. Because if they didn't have a court appearance where they were addressing this in court, where they were getting verbal reasons, then this basically just says, weren't you listening, guys? And yeah, like Judge Escarati doesn't feel the need to write this down and include it. She does, however, feel the need to expand a little bit upon reason number 7. And that is our favorite thing, this whole bizarre thing about the jury. All right. So, defendant, denied for the reasons outlined below. Purpose of the voir dire is to obtain a fair and impartial jury. Voir dire is necessary to ascertain whether any juror has an interest in the case or any bias or prejudice in relation to it, and that he in fact stands indifferent to the cause. So voir dire is that whole process where you investigate the jury and you question them and you determine if these jurors are people who should be on the should be listening, should be there doing the decision making. So voir dire is real important, and voir dire is where this should have been discovered, right? So yeah. And I see this. I already ruled on this. You know this. You provided no additional justification. I am not rehashing it. You get this one-liner denied. That's it. Yep. So, yeah. All right. Let's the summons issued to Juror 15 listed his legal name and address, and no birth date was noted. The court has pulled Juror 15's jury questionnaire, attached as redacted, filed under seal. So what that means is that they attached a redacted version, so we don't get to see the full details about the jury, but they filed a full and unredacted version under seal. That's part of the court record, but you can't access that. That's so that the parties can see the full thing, but I can't go and look up Juror 15's home address. So yeah. And I see somebody saying, didn't Law and Lumber basically predict the one-line response? Yes. In fact, we could have gone a little further. She could have just straight up said, hey, I'm denying all of these as without merit. That could have been an answer. So the information presented on the jury questionnaires matches the information Juror 15 provided to the court. Juror 15 was vetted by the court on the record and met the statutory requirements for service. The parties also questioned the jury panel for a full day and informed the court that the jury panel was acceptable. Therefore, due process was guaranteed and provided to all parties in this litigation. Because, Elaine, you could have turned your mic on and you could have, said, hey, doesn't that guy look real young? Yeah. Voir dire was conducted in a fair and impartial manner with the court and both parties examining the potential jurors. There's no evidence of fraud or wrongdoing. Let's scroll to the bottom and have a look at this jury questionnaire. So jury questionnaire are from August 2021. And yeah. So there's a whole bunch. This is just kind of a blank aspect here. Now, some things I just want to note here. Date of birth was noted as 1970. So, that was, listed. Do you own real estate in the Fairfax County or the city of Fairfax? So, yes. So that's interesting that they asked that question. Employer, self-employed. Cell phone, obviously redacted because, yep. And occupation, IT management. Did I not call this during the trial? Did I not call and say, hey, I'm seeing some people perk up when they start talking about when they start talking about the real technical IT stuff? Did I not call that and say, I think that there are some people on this jury who are involved in IT because I'm seeing some people look up and, get real interested at these, IT aspects when they're talking about metadata and when they're talking about this guy's, when they were talking about that one expert's, credentials in terms of his involvement in Linux and so forth. Yeah, I did. And IT management. If I was Amber's team, I'm just going to tell you, I would have fought like mad to keep anybody with IT off the jury. I would have been saying, do not want. I want somebody who is ignorant as hell. Yeah, and I'm just seeing somebody there going, he's probably also the guy who totally buys the Wi-Fi on the plane, too. Yeah, I mean, if you're involved in IT management, this is something where you might need to be accessible for emergency calls. And you might need to, for instance, do some network stuff from 10,000 feet in the air. This guy's version of the Mile High Club is probably something like, got a web page back up and running and an e-commerce platform functioning again from on a plane. How they let this guy on the jury is just beyond me. So, I mean, this is, yeah. That to me seems like some bad jury research here, but somebody says, if you want IT illiterate, they'd have to be over 70. Lol. Yeah, they might have said, hey, this guy's real old. We like that. But IT management, come on. All right. Do you own real estate? Yep. I don't know why they asked that, but I mean, I don't know what Fairfax County's real estate prices are like. Out here, real estate is getting super expensive. So it is, it's a measure of success if you're managing to own a house here. Somebody's asking, what am I drinking? Right now, it's just a Coke, which is super boring. I am probably soon gonna, once I wrap this up, I'm gonna see if, about possibly I might end up jumping on another stream. If I do that, I'm gonna pour myself a gin and tonic because I've been hankering for one. Somebody says Spiegel was the highlight for me. I think he single-handedly ruined Amber X. Good lad. Yeah. And I see somebody saying Fairfax County is very expensive. Yeah. I've heard that it's sort of an area where a lot of sort of government movers and shakers live. So yeah. Yeah. See, IT self-employed in Fairfax, he's definitely rich. Yeah, one of the jurors, if it was juror 7 instead of 6, which is theoretically possible, then yeah. And I see somebody saying, what stream might I be joining? Might be popping on Christina Pickles, or Pickles rather, not Pickles, Pickles. Her show, I don't know. I'll just have to see. So jury questionnaire, United States citizen. Yep. Resident of Virginia for the past 12 months. Yep. So all of these things, unable to serve due to a mental impairment. Nope. Have been convicted of treason or felony. So treason's an interesting one. Also, why do they say treason or felony? And, is treason not a felony? It must be, yeah. And possible exemptions. Check the appropriate box if you wish to claim an exemption. Now, this is interesting because at least where I am, there's different categories of exemptions. There are exemptions that are like mandatory. I am a lawyer, and so where I am banned from serving on a jury. If I show up like with a jury notice and I say, I want to be on this jury, the court is to kick me off the jury. They are required to do so. Absolutely required to do so. However, there's all sorts of things that are discretionary, which is that the court may or may not kick you off, and where often you have to indicate that you want to be removed for that reason. And so some of those are, for instance, I'm working, right? Like I can't, like, let's say you have your own business and and your business will literally collapse if you're not there, right? You're in IT management and, you literally cannot function because you're the only person and so forth. Then they might let you off the jury. But this guy seems to not only have his own company, but have one that can run in his absence. That's impressive. All right. So I am 70 years of age or older and do not wish to serve. It looks like you might actually be able to serve even if you're over 70. I'm going to have to go back and look at Elaine's filings because it seemed like they suggested, I saw some suggestions that you can't, that you can't serve if you're over 70. That doesn't look like it's the case. Lilith, I wish they would just order Amber to just shut the blank up and go away. Can they do that, please? Not really. She's got a right to speak. I see not all felonies are treason. Yes, but you'd think all treasons would be felonies, right? So that's kind of an LSAT sufficient and necessary issue, but yeah. So other exemptions, I'm a mother breastfeeding a child, member of the armed service, and will be outside the United States. Magistrate or sworn or licensed practicing attorney, judge of any court. So some of these must be mandatory and some of them may be discretionary. So yeah, it's unclear. So, and they block out the signature there. And they also note that if ADA accommodations are needed, please call. And so if you have, if you have issues, they can actually, address those. So yeah, he got a notice. I kind of wanted to show that just because I was, was like called it on the IT aspect. So yeah. All right. Further, the defendant was provided the jury list 5 days prior to the commencement of trial and knew or should have known about the mistake at any time during the 7-week pendency of this trial. 7 weeks. 7 weeks is a long time, especially when you got this kind of budget, right? She had every opportunity to object to or voir dire on the issue. Parties generally must make objections at the time a ruling or order is made or put to the court on notice that an issue is meant to be preserved. Somebody's saying, what jurors did I think belonged in IT? I think it was jurors 1, 6, and 7. And I was less on 6, and 6 may well be juror 15. I was less sure on that because, frankly, because juror 6 seemed like an older guy, and just playing the odds, that's less likely. But yeah. I see people saying that they hope to see me on Emily. I'll be on Emily if she invites me, but I mean, she's got her own, she does just fine on her own. So, and often you just want to do a stream on your own, right? So, yep. And I see people saying I can find recovery clothing. That's a good idea. I'll have to have a look on that. Why would an IT guy not be an ideal Amber supporter? Because an IT guy is going to be able to pick through that her metadata crap is really damaging. An IT guy is going to look at those details like, oh, look, the metadata for these 2 pictures is exactly the same, and is going to say, that's a smoking gun. Like that. Whereas somebody who isn't in IT might not understand just how significant that is and how big of a deal that is. So, yeah. Further, the defendant was provided the jury list. So, yeah, she had every opportunity to object to or voir dire on the issue. Parties generally must make objections at the time a ruling or order is made, or put the court on notice that an issue is meant to be preserved. Despite defendant's assertion in footnote 9 of the motion, Virginia Code clearly states. So, despite their assertion, your assertion is wrong. Any error in the information shown on such copy shall not be grounds for mistrial or assignable as error on appeal. And the parties in the case shall be responsible for verifying the accuracy of such information. Emphasis added. So she had, as I've been saying, she had a positive obligation to check that out. And so I had somebody on Twitter who was saying, oh, no, this is a big deal, and she didn't have to find it, and she didn't. And then, of course, once I was disagreeing with that and providing, the references, they were like, and then they blocked me, of course, because that's just how those bots go. But yeah, I see Jefferson C. Post in Massachusetts, even judges could be called for jury duty. That baffles me, because if I was a lawyer, I would want that judge off the panel right away, because yeah, you don't want them to you don't want one person swaying the entire jury, and that's a risk on that. Amber Heard's behavior is to look everyone down. She won't see I'm not sure on the IT guy. Just look at the caliber of her experts, my humble opinion. Yeah. Or won't see the threat, I guess, on the IT guy. Yeah, it's so consequently, defendant as well as plaintiff had an affirmative obligation to ensure the accuracy of the information provided for the jury panel. This is the best part. This part is just magical, because this is sorry, I'm just going to mute for a second because I got to sneeze. Sorry, folks, you didn't need to hear that. So this is really magical, because this is putting a spike on this, not just for the case now, but also for the appeal, because now this is this is almost a factual finding. This is this is just wonderful. So a party cannot wait until receiving an adverse verdict to object for the first time on an issue known since the beginning of trial. This issue, or the issue, has been waived. The suggestion here is basically one of impropriety. The suggestion here is that that they knew about this and they sat on it like, drum roll please, a malicious law squirrel. And I mean, Judge Ascarati is not going to use the phrase malicious law squirrel, but that is what she's saying. She was saying, sorry, Elaine, you are being a malicious law squirrel here, and you can't do that. You can't hold on to these issues for appeal. So, and I see we've got Uncivil in the chat with malicious law squirrel. I got to find an artist to do a drawing, and I got to make a malicious law squirrel, malicious law squirrel thing there. So, somebody says, is there ever a circumstance where I would want a lawyer on the jury? I might, if my argument was one that was weak on, that was something that people are inclined to rule against normally, but the law is on my side. That's where I might want a lawyer on the panel. So, all right. So the issue has been waived. And then, even if, arguendo, the objection has not been waived, objections to any alleged discrepancies in jury lists and any legal disabilities of potential jurors must be made in accordance with Virginia Code Section 801-352. Now, arguendo is not, it's not sort of unknown. It's not like a turn of phrase that nobody uses. But I just thought it was really interesting that we see arguendo appear in, arguendo appears in both the original decision, or the sort of the motion there, as well as now in the actual decision. And I don't know. I mean, it's hard to tell, although I will say that the decision here seems to parallel the arguments and the structure of Ben Chu's filings, of Depp's team's filings. And you always love to see it when the court is basically adopting your filings and writing them out again in your own words. And I think that's part of what's going on here. So even if arguendo, so again, for the sake of argument, we think, like I've already said, that this is garbage, but even if it weren't garbage, objections to any alleged discrepancies in jury lists must be made in accordance with the code. And I just see, I wish you could fill out those jury questions in advance. I got told bye as soon as they heard registered nurse, but wasted hours of time and money. Yeah, I mean, it is annoying when you're doing all these things there. I love this off topic, but could you please have a quick look at some point in your Twitter DMs? I will do so as soon as I can here. Yeah, that's, I'm not sure if that's something that's sort of urgent here, but I will have a look sort of once I can. So just to come back to the stream here. Attention deficit going wild. That's just kind of how I roll. Unless objection is to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional or that the irregularity or disability be such as to probably cause injustice in a civil case to the party making the objection, then such irregularity or disability shall not be cause for summoning a new panel or juror or for setting aside a verdict or granting a new trial. Now, subsection A was you had to object at the trial and you had to object at the time. But they also note you have to show prejudice. And, I think everybody looking at this has been saying they can't show prejudice because there wasn't any. All they can do is speculate about improper motives, but they don't have anything whatsoever to substantiate that. And that is just absolutely ridiculous. And somebody says that they're guessing it's juror number 9. I would really like to find an answer to that. I don't have a good answer. So I would love to see a seating plan matched with juror numbers. Maybe I'll reach out and I think if anyone can get that, it'd be Chanley. So let me see if I can reach out to it. Malicious law squirrel is someone who holds on to evidence or squirrels it away until they find they can use it to best advantage, essentially lying intentionally. Yeah, it's basically, what it's referring to here is they're holding on to an objection. They're basically saying, that oh, we're not going to object in timely fashion. We're going to save that and then bring that up. And I see what's this? All right. Furthermore, while parties must make this objection while following the above procedure, the party moving under this code section must provide some evidence of prejudice. Defendant has neither followed the proper procedure nor shown evidence of prejudice. You didn't do it right, and you can't meet the test, and you didn't do it right. Come on. Defendant does not allege Juror 15's inclusion on the jury prejudiced her in any way. The juror was vetted, sat for the entire jury, deliberated, and reached a verdict. The only evidence before this court is that this juror and all jurors followed their oaths, the court instructions, and orders. This court is bound by the competent jurisdiction or decision of the jury. Love it. This order is final, period. Now, I mean, this looks like it's a higher, larger, font there. Now, endorsement of this order by counsel of record for the parties is waived in the discretion of the court pursuant to Rule 1.13 of the Supreme Court of Virginia. Now, normally when an order is being filed, you get the lawyers to sign off on it to basically say, we agree that this is the order that the court was given, right? Like the court gave an order and we agree that, and it's also just kind of, you get the lawyers to sign off on it just kind of so that, everybody can go and, it's like, well, you signed it kind of thing, right? But in this case, the judge has exercised her discretion to be like, I'm not even, you guys don't get any comment on this. You guys don't get any, there's no opportunity for you guys to, clap back or anything like that. I'm not going to hear anything more on this. The order is final, period. And then, we don't even need your signature. I don't need to hear from you any further on this. This case is done. Move on. Either appeal it or don't. And if you're going to appeal it, let's see those 10 million bones. And yeah, I'm just stunned. And it goes on. This is the other, sort of, there's a little footnote here. See yellow cab of Abington and Henderson, noting that the possibilities of prejudice are not sufficient to overturn a verdict in the overly administration of justice. And they also cite sustaining the judgment of a trial court's decision where two felons sat on the jury because the defendant made no showing of probable injustice. Gee, who cited that decision? Who was it who, oh, right. The person who cited that one was, yes, that was Ben Chu. They're relying on the case law directly out of that. So that is lovely. I also missed a footnote that I want to bring back here. Just let's pull that up here. So this is a footnote from the motion to strike. Defendant seems to have abandoned her prior baseless assertions made by both Ms. Heard and her counsel on national television that the jurors violated their oaths by watching social media during the trial, which in turn influenced their verdicts. Disgraceful that Ms. Heard made such scandalous allegations and disappointing that no apology and recantation followed. I'm just pointing this out because there is literally no argument here. There is not a single argument being made here. This is not, you should fine for me because of this. This is not, you should rule in, this is not their argument is weaker because of this. This is just screw these guys. And man, is it nice when you can, as a lawyer, when you can put in like, also screw these guys into a filing. Like they just basically take the moment in their legal filing to call out Ms. Heard and really by extension her legal team. So yeah, what we see in this is a whole lot of like, what if any point do you have, Ms. Bredehoft? Like, where are you going with this? Why are you doing this? Why do you think that this is something like why? Um, and I mean, I said before that I had been thinking of doing a video kind of in defense of Elaine, and then she got me to back off of that with her media tour. And now I am absolutely, I'm so glad I didn't make that video, because I would have to make a recantation video on that one. And I'm not really a big fan of having to do a recantation video where I have to, back up on things and just be like, yeah, I oopsed. I try to avoid being in that situation, but I mean, the order is written in really direct language, and it basically just is a nonstop train of slapping down all of the, all of the arguments. It's just, first of all, 1 through 6. Yeah, I already explained this. Goodbye. And 7, let's just go through in detail. And I think that the reason why she does this, why Judge Ascarati does this with the juror issue, is because there's this implied suggestion. They basically made this suggestion that for some reason, juror 15, was trying to get on this jury somehow, that he was doing something improper, that he was doing, something unethical or unfair or something along those lines. And Judge Ascarati comes out, and I think that this is both trying to put a nail in that issue as an appellate issue, because like she just says, hey, we are, this has no merit to it whatsoever. She doesn't give this argument a single inch. And, the other thing is that she really comes out and stands up for juror 15. She says there's not a single whisper of evidence, and I'm not quoting, I'm just, providing a sort of a paraphrase here, but there's not a single whisper of evidence of any impropriety. There is not a thread of anything wrong on this. So how dare you? How dare you throw this guy who, we talk about, doing your service, doing your, jury duty is a service to the country. It's a service to the public. So it is it's an absolute, it's basically an act of charity, because you get paid nothing basically to be on a jury. You just get, it sucks being on a jury, and it's unpleasant. It's boring as hell a lot of the time. I was sitting there in court, and I can tell you there were a lot of people in court struggling to stay awake when they were going through all of those video depositions. Remember that video deposition day and how much that sucked? The jury's got that nonstop. The jury's got lots of days of that. The jury's, sitting there, and they have to pay attention. They have to, all of these things. To come out and with nothing, throw shade at those jurors, it's like if you lose your wallet and somebody comes to the door and is like, hey, I found your wallet. I traveled across town. All the money is still in it. I just wanted you to have your wallet, and you take the wallet and you go, thank you. And then you spit right in their face. Like, it is an absolute, it's ugly. I really don't like that they did this. I really, really don't like that they did this. Jackie H. Hi, Runkle. Do a search on, and I see these stars to avoid YouTube with dog recovery leg, and you'll see some garments that cover the wounds to stop chewing and licking. Good luck. I will have to check that out. Thank you very much, and thank you for the super chat. Emily said that she tried to give Elaine grace, and that I taught her to give her even more grace, but she also said the days of being gracious to Elaine are over. Absolutely. I have run out of patience for this, because this is just ugly. This is, let's say I was running a law firm and I had a junior associate, and I found out that this was how they were running a trial, that they were making this kind of argument with no evidence. I would probably have a talk with them and say, hey, is this really, you look at this, do you actually think that this argument was going to fly? And that's the first question is, did you think this argument was going to fly? Because if so, we've got questions about your legal judgment, your legal acumen. Does this does this comport with what makes sense to you? And what is it? Is this how you think as a lawyer? And that would be my first question: is that something that is really just how they, do they have so little understanding of what the legal process is like that they actually thought this was a good argument? And, assuming that they knew that this was not likely to carry the day, that it was an absolute reach and, so forth. And what is it? Then what is it? The situation, I would be asking, is this how you want your reputation to be? Is this how you want judges and other lawyers to think about how you conduct your practice? Because if so, you are necessarily you're kind of cutting your own throat in the long term. So yeah, Uncivil, can I get a redirect from the stream? I didn't know you were streaming, and I already promised I was a redirect to Miss Pickles. So I'm sorry I can't do it today. I will on another occasion. Sorry, man. But Uncivil also does great stuff. What are you covering, Uncivil? We can give you a shout out because not everyone's going to want to watch what Miss Pickles is up to, and some people will certainly be interested in all of that. Caden's mom, thank you for the $5. I can't wait for all the unsealed documents. Me either, and absolutely, it'll be real interesting. But also being a juror with the pressure of knowing this is a high-profile case over a long time. Claims Elaine and Amber Heard were so insulting because they were baseless. Absolutely. It's ridiculous. It's just ridiculous. Thank you, Debbie White, for the super sticker there. I just have some serious kind of issues as to I have issues as to what is going on all of this. I don't like this kind of argument. I think that this is ugly there. And they say here in the Washington, D.C. metro area, Maryland's suburb, not only do they pay something like $30 a day, but they also ask you to donate that to the court if you don't need it. You have to basically be independently wealthy, or you have to be set up with a job that allows you to do the work that allows you to do jury duty without that. So yeah, it's that. I see. I'm covering Ring doorbell privacy controversy. Ring shared info with government against privacy policies. That is cool. I don't know if I probably can't watch that live, but I certainly would. I will watch that afterwards because that's right up my alley in terms of interesting things there. Have you seen pictures of Elaine fangirling it at a Johnny Depp public appearance red carpet event? I did see that. I can't say for certain. It's probably Elaine. I can't say for certain, but yeah. Anyway, so we've had a look at all of this stuff. The ruling is not surprising. And it's also, I had said before that there was going to be some discussion that I didn't think that sanctions were likely to be issued. I thought that they could, and I thought and I said I really would like to see them. But I don't think that they're going to happen, and I think it's in large part because Judge Escarati is one of the most level-headed judges I've ever seen. I very much don't imagine that I think she's able to sort of take stuff that annoys her and put it past her really seriously. I think that that's sort of within her wheelhouse, and I think she wants to preserve this and shut down any argument of bias. So I think that that's kind of the thing there. All right, so I'm gonna wrap it up here. I'm not sure where I'll be. I might try to pop on another stream elsewhere, but yeah, this is fantastic. I see here somebody saying there should be a law that employers must count employees and jury duty as working, continue to pay them. The standards set for contract and salaried workers. Yes, although that might be really bad for very small businesses that have like 1 or 2 employees, but you can put in exceptions for all that. What do you think are going to be Amber Heard's argument for appeals? The same issues minus the jury issues? I think it's going to be all the same issues. I think she's going to try every aspect, the same. And I think she's going to go, but I think her big argument for appeal, the real big hurdle to overcome, is $10 million. Well, I want to see if she gets that $10 million together, because if she gets that $10 million together and she loses the appeal, they don't pay that back to her. They pay that to Johnny Depp. So it might be the only way Johnny Depp sees that money is if she appeals it. So yeah, we will keep seeing what happens on this one. I owe you guys some videos on other topics. There's a case that I just read about today that I want to cover. There's the case of the Queen and Brown, which is about extreme intoxication and those issues. There's some other cases. So yeah, there should be a redirect here for Ms. Pickles. So hopefully that will function. But until then, I'll see you guys next time. Cheers.